Support comes from Mosby Building Arts, upgrading windows to help curb appeal and keep homes efficient. More at callmosby.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. A federal judge is livid at attorneys for the city of St. Louis. He called their work slipshod and said he'd consider sanctions. What could that mean for the lawyers who filed the case? And another federal judge will decide the fate of KDHX. The community radio station filed for bankruptcy, but could a separate suit in state court interrupt that proceeding? And staffing shortages at the Missouri Attorney General's office are leading to big delays for people suing the state. Is there anything the judicial system could do to keep things moving? These are questions only a good lawyer could answer. And today, we have three of them with us here. Yes, it's our Legal Roundtable. And I'm excited to say that today we're joined by one of the Roundtable's founding members. That is Bill Freivogel. He's an attorney and a professor for the School of Journalism at Southern Illinois University, Carbondale. Bill, welcome back.
Hi.
And we're also joined today by Sarah Swatosh. She is a labor and employment lawyer who is in private practice at the law office of Sarah Swatosh. Sarah, welcome.
Thank you.
And then today, a special treat, making her Legal Roundtable debut is Judge Nannette Baker. She served as Chief Magistrate Judge in the Eastern District of Missouri from 2016 to 2021. She previously served on the Missouri Court of Appeals in the Eastern District of Missouri for 6 years and was Chief Judge from 2008 until 2009. She was the first African-American woman to be appointed to that court, and she has also been a circuit court judge in the city of St. Louis. That is quite an impressive resume. This is a real treat. Judge Baker, thank you so much for joining us.
Thank you very much. I'm happy to be here.
So let's dive right in. We have so much on the docket today. That's a little legal joke there. A federal judge, as I mentioned, is irate at lawyers for the city of St. Louis. Judge Matthew Shelp accused them of filing a slipshod lawsuit and making a mistake that he said even a first-year law student would be aware of. His blistering order came in response to the city's lawsuit seeking to block the governor's office from taking control of the St. Louis Police Department. And he has suggested the city's lawyers could be sanctioned for filing a frivolous lawsuit. So let's set aside for a moment that this is whether or not this is frivolous. That is a question I want to get to. But Bill, they filed in federal court. They didn't name the state's attorney general as the person they were suing. Is Judge Shelp right? Is that something a 1L would know?
Yes, but he's right about that. I think that Chuck Hatfield, who's I guess the lawyer for
he was the lawyer for Megan Green
in the case.
Also, the city councilor's office was involved.
Acknowledges that they should have named the attorney general. The 11th Amendment says people can't sue the state in federal court. But there's a Supreme Court precedent, Ex parte Younger, which says that if a state official is enforcing some sort of a state law, that infringes on federal rights, that then the state official can be sued under certain circumstances. So, yes, and Hatfield admits he should have. They should have named the attorney general. Let
me stop you right there. Is that the kind of mistake that would be easy to amend? Just chuck in a new pleading and get that guy's name on there.
I think it would be.
Yes, it absolutely would be.
And that's what he said.
Yes.
Yeah. And yet, it seems like the judge is pretty angry about this. Is it unusual to see a judge blast the city for saying even a first-year law student would know this versus waiting for maybe the other side to make that kind of argument? Judge Baker.
Well, the judge gave them a deadline to amend or to address the issue. And they didn't. I mean, the first thing that a judge does when they get a pleading before them is to make sure that they have the jurisdiction over the case. You can't go forward if you don't. And one of the simple things in this case was the fact that the state had been sued and they have sovereign immunity. So the first thing you want to do is go reach back out to the attorneys and say, this is a problem, and correct it. and they didn't correct it. And I think that's why the judge is angry. Not that the suit was filed in the first place, but that they didn't even bother to address it.
Yeah. Sarah, that feels like maybe a big mistake on their part not to get another filing in there pretty quickly.
Yes, the judge said the city altogether ignored the court's order and abandoned their case without so much as a muttering retreat. In the words of the great philosopher Homer Simpson, I thought, that's bad. You don't just ignore the court order. You dismiss, you amend, you seek more time. You just don't ignore. It was a big oomph.
So he says he may issue sanctions in this. What kind of finding would he have to make here in order for them to be hit with sanctions? I mean, can he just say, look, you had a deadline, you blew past it, I'm going to fine you?
And it was done for political reasons and to harass the sovereign state of Missouri. Yeah, I would just say that I did think his order was over the top. I noticed you quoted Dave Rowland saying unusually sharp. Yeah, unusually sharp. I mean, it was needlessly nasty. But particularly, like the footnote on Chuck Hatfield. Oh, he just got an award. He certainly should know this.
It felt a little personal, that
it felt very
footnote
personal,
in particular. So I'm kind of torn here. Judge Baker, I'd love your perspective because on one hand, they did blow off this deadline. The judge gave them this chance to amend it. And you say that's a big deal that they just let that go. Do you think the sort of reaction was outsized in light of that fact?
I agree that it did seem like a particularly sharp order. I think that he could have done the order to show cause without putting in all of that additional information, because there is a question about the timing of the lawsuit. It was done the last day of that administration. There are some questions, and it did appear to be, I don't know if I would call it slipshod, but it was done rather quickly, it appears. And so I think that in order to show cause was the right thing. I think the language in the order may have been a little over the top.
So, Sarah, what do you think we'll see here? I mean, I heard people say, oh, Chuck Hatfield could get disbarred for that. I said, I don't think that'll happen in any universe. Are we talking about a monetary fine? Am I wrong to say somebody would never get disbarred for failing to amend a complaint? I've certainly never heard of that.
I would be astonished if he were disbarred. I honestly don't know what sanction the judge could have in mind, and I would be scared to speculate on what the judge would do there. But I do have a sense that EDMO is pretty measured, and I think...
I'm sorry, what's EDMO?
Oh, I'm sorry, Eastern District of Missouri Federal Court. I suspect the court is tired of being weaponized for... I mean, if we look at Andrew Bailey and Schmidt, they're suing China. I don't think Eastern District of Missouri wants any of that nonsense. And so they're saying, hey, Sheena Hamilton, hey, Tashara Jones, hey, Kara Spencer, we're not engaging in it here. So if you have a claim, a legitimate claim, bring it. If you don't, it's going to be a problem. So I don't know what sanction he could give. He's got a lot of remedies out there. I don't know what he would do.
I'm not sure if this judge feels as though some of those other examples of weaponization are ones that he would be upset with. He was the judge who ruled in Biden versus Missouri that CDC could not have a vaccine mandate for health care workers during COVID, something that the Supreme Court pretty strongly disagreed with.
Yeah, so this is a Trump appointee who maybe is not so wound up about the politicization that some liberals see on that side, but did feel like the city of St. Louis was doing that in this case. Judge Baker, you were with the Eastern District of Missouri as a magistrate. Do you feel like there is a frustration with federal judges? They don't want to see people trying their cases in the media, filing lawsuits just to get the headline they want.
I think that's true. I think that's true on any level, that judges don't want to see that. I'm not going to go into the politics of my former colleague, Judge Shelp, or anyone else. Obviously, the district judges are appointed by various presidents. Generally, that does not guide how they make their decisions. I will say that. In this case, talking about the sanctions, I mean, there are non-monetary directives. There can be penalties paid to to the court, or there can be an order paying the opposing party attorney's fees. So those are some of the potential sanctions that could be there.
What would be a non-monetary directive?
That's a really good question because I see it there and I'm like, non-monetary, I don't know. Are you going to apologize? I don't know what exactly that would be. Normally it would be something in the line of some sort of monetary sanctions, or attorney's fees are a common sanction in this type of situation.
Okay, so attorney's fees, that can get steep. On the other hand, this case hasn't been pending that long before it got dismissed.
Hopefully the city, if it filed another if Green files another complaint, it will spell Constitution right.
Is that the word that was misspelled?
One of the words.
Wow. Well, Megan Green has said that she does wish to refile this case now that there has been such umbrage around this missed deadline. It will be interesting to see what happens next.
And the city councilor had just resigned the day before or something.
It was bad timing.
Yeah, so
it was an office in transition.
It was, yeah.
So our next case involved not a judge getting angry at litigants, but victims who are very disappointed and maybe even angry at a judge. Judge Ellen Roboto sentenced Matthew McCulloch to 5 years probation for firing his gun into the air at a crowded trunk or treat in Kirkwood. Matthew McCulloch also yelled, allegedly, "You're all going to die." McCulloch is the son of longtime prosecuting attorney Bob McCulloch. And Judge Roboto did factor that into her decision. She suggested that Matthew McCulloch could be in danger in prison because of the many criminals that his father put away. Judge Baker, is it fair to consider that? What do you think of this ruling where he ended up getting probation and victims wanted to see a lot more?
I think, first of all, in this case, that the defendant entered into a blind plea. So what that means is that the defendant was pleading guilty without any agreed-upon sentencing recommendation from the prosecutor. My understanding is the prosecutor did suggest a 3-year sentence. When you are a judge, first of all, doing sentencing is the most difficult thing I think that trial judges do. And especially in cases like this, where a defendant has no criminal history. He was a police officer. He had a mental illness, which they testified to, and there was testimony that he was in a manic situation when this occurrence. You take all of those factors into consideration. Obviously, you listen to the victims and the
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
What the victims recounted was absolutely horrible. I mean, there's no doubt about it. But you also have to look at how the system works. So if she had followed the 3-year recommendation, he would not have spent that much time in prison. Even factoring in, considerations of danger, he probably would not have been housed in Missouri. That is a true thing. But you also have to consider how much time. So in this case, fashioning a probation, so she sentenced him to 7 years on each of the 6 counts of child endangerment and 4 years on the count for the gun charge. And she did say that they would run concurrently, but she suspended the sentence. So one thing to remember is, since she sentenced him, he does have felony convictions on his record. There is a way to do this and do a suspended imposition of sentence, which would mean the person wouldn't have a conviction. So he has a conviction on his record. She set in some very, very specific conditions of his probation, and she is going to basically supervise that and make sure that he's following that, which I think is a better sentence than someone who spends, let's say, 9 months in prison, comes out and doesn't have really these types of conditions on them.
Yeah. I mean, you make a great case here that this is far more nuanced and complicated than what the headlines have suggested, that this guy got off with a slap on the wrist. You mentioned if he had been sentenced to 3 years in prison, he wouldn't do anything close to 3 years. If somebody is sentenced to 7 years of probation, will they do 7 years of probation?
Well, she sentenced him, I believe, to
5
years. And she said that she could add on a 6th year. Usually it's a 5-year probation. Yes, they stay on probation for that entire time.
Okay.
I did this sentence quite often when I was on the state trial court. for various reasons. And there are just a lot more things to factor in. I think everyone wants to just put them in jail and you think, okay, then they'll be there for that whole time. But the truth is they're not. And when they get out, they don't have the types of conditions that she's put on him.
Sarah, any thoughts on this one?
I agree. I mean, when you read it, you're just appalled that he didn't go to jail. And you think, oh, his father's the prosecutor. Oh, there's political connections. And that could have had something to do with it. But I also look at Judge Roboto, very well respected. She's a former defense attorney and a former public defender. And so I think she sees more humanity. She sees more humanity in the situation. And I think she does say, if we put him in a Missouri prison, he would not be safe. You know, the other part of me says, well, so what? Yeah, so what? Send him to Oklahoma. I don't think she made a bad decision by any means. I wouldn't critique it, but it just doesn't sit right, even if it's the right decision.
Bill, I get the sense you may want to argue with our other distinguished panelists.
I would disagree. I mean, I'll just ask myself the question: if Michael Brown had stood in the middle of a parking lot, Kirkwood school, and fired into the air and said, "You're all going to die," do we think this would have been what happened to him? No, it wouldn't have been. And so I do think it really smacks of favoritism. I thought Judge Roboto had a sort of a strange comment where she said this was a loss of innocence for Kirkwood. Of course, the loss of innocence came a number of years earlier at the City Hall massacre. But this was a loss of innocence for Kirkwood. But I see people who every day, who are facing this kind of violence. Well, I mean, I thought that was a strange way to put it. And I'm afraid if he's in a prison in another state, he might not get his medications. I mean, surely someone can arrange to get the medications to him. So no, I did not think it was a good decision.
You would be surprised how difficult it is to get medication to people in custody. A lot of people that I saw when I was on the federal bench had so many issues getting treated for mental illness. It's a real problem. So I think it's a valid consideration. Okay. I think your points, though, are well made. I think when you compare to another person who may have done the same thing, what would that sentence be? It's so individualized. And it really, a lot of it depends on the judge. There may have been another judge who would just say, no matter what, I'm throwing the book at them. But like I said, these are the most difficult decisions that trial judges make.
Boy, and just hearing our panel discuss this issue, I find myself being swayed and being swayed back again. So, boy, I guess I never want to be a judge, and thank God we're in no danger of that. We're talking today to our legal roundtable. That is retired Judge Nannette Baker. We're also joined by Bill Freivogel and Sarah Swatosh. When we come back, we're going to talk about KDHX and a high-profile bankruptcy. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm the executive editor of St. Louis Magazine. I come back once a month to host this legal roundtable. It is always the high point of my month because I have so many questions about cases that are in the news, lawsuits that have been covered. This is my chance to pick the brains of three expert attorneys. Today we have with us Bill Freivogel, an attorney and professor for the School of Journalism at Southern Illinois University, Carbondale. We're also joined by Judge Nannette Baker, the now retired Chief Magistrate Judge in the Eastern District of Missouri. She's also the former Chief Judge of the Missouri Court of Appeals for the Eastern District of Missouri and a former Circuit Court Judge in the city of St. Louis. And last but never least, we're joined by Sarah Swatosh. She's a labor and employment attorney. She's in private practice at the law office of Sarah Swatosh. So, Sarah, I want to talk about the nonprofit that governs KDHX. They filed for bankruptcy. They are seeking to sell the station's broadcast license to cover its debts. It sounds like there's going to be an auction auction, and there's a group of community members who want to preserve the broadcast license. They aim to bid in this auction. There's also 2 Christian radio companies, very large entities, that apparently can pay top dollar for this, pay a lot more than this community group. Now, I know no one here at this Legal Roundtable is a bankruptcy expert. That seems to be the one type of lawyer we seldom get on the show. We should add one to our roster. But with your understanding of how this auction could work, does the nonprofit's mission matter now that they're in bankruptcy? Does this come down to the highest bidder, or does it come down to what KDHX was meant to be and founded to be?
So when there's a bankruptcy filed, a trustee is usually appointed, and the trustee has a fiduciary obligation to ensure that debts are paid. And the trustee comes up with a plan for either a reorganization or a liquidation, but their job is essentially to get the debts paid. And so mission can be important and mission can be considered, but it's not the primary goal. The most notable case really on the issue was the Archdiocese of Portland, Oregon. Back in 2004, the Archdiocese was just hit with a slew of settlements and lawsuits for all the sexual abuse, and it was north of $50 million. It was a lot of money. And so the Archdiocese of Portland went to claim bankruptcy and reorganize, and the Catholic Church came forward and said, hey, this is our mission. Don't take our assets. And of course, you have these victims of the abuse saying, we deserve our compensation. You can't hide, you can't cloak, you can't hide our money essentially in your religious mission. And it was a tough decision. And ultimately, the bankruptcy court came in and said, yes, we recognize that the Catholic Church has an important mission for parishes and education and homeless and all of the things that the sort of Catholic Church does. And so the bankruptcy court came in and said, because I think they owned several $1 million. I mean, I think New York City has $7 billion in assets in the Catholic Church and just land.
The real estate is astounding.
is shocking because it's parishes and it's lots of stuff. And so the bankruptcy court came in and said, if the real estate is held in an actual trust, we will not consider that property as part of the trust asset that can be sold to pay off the debt for these victims. But if it's an unrecorded deed, if it's not in an actual trust, then they will sell it to pay off, to pay the settlements for these abuse victims. And so I think mission can come into account, but it's not the primary goal. The primary goal of the trustee is to make sure that creditors are paid.
So what's complicated here is that there are some creditors, and I imagine that bill is growing as they pay bankruptcy attorneys, but the price of this broadcast license far exceeds the debt. And the board is arguing, hey, we want to keep going. We need the assets to keep paying an executive director to do some sort of online station, and getting top dollar for this license will allow us to do that. On the other hand, you have critics of the board who are saying, hey, wait a minute, it's important to have this radio license. This is how people are listening to this. We have this whole digital divide. Low-income people don't necessarily have access to streaming stations. This is absolutely mission critical here. How would you begin to sort that out?
So from what I understand, K-Love, a Christian network, has offered $4.9 million. Another Christian network, Joy FM, has offered $5.3 million. And I believe the debts are just a little north of 2.
That's right.
Right. And so you shouldn't have to sell the entire license. You shouldn't have to sell the entire license to pay off the debt. And I know this isn't quite on point, but when in my cases, if a plaintiff comes in with a lawsuit and there's a bankruptcy and a trustee, the trustee for my client can come in and settle the case. I might say to the trustee, hey, the case is worth $500,000, don't settle it. And the trustee will say, she's got $100,000 in debt. I'm taking the bird in the hand. I'm taking the $100,000 settlement, even though you think it's worth $500,000. So a trustee could come in and say, this money out there is speculative. We don't know if it's going to come in. We don't know if we can save the license. We need to take the money. the trustee could give him a little bit more time, but I don't know if the trustee would.
So Sarah, that is an excellent, very interesting analysis. Thank you for digging into bankruptcy law to illuminate all of us. You may have a question or comment about this topic. We're at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air. Again, we have no bankruptcy experts here. We may not know the answer, but we're going to try to chew on all this. And Bill, I want you to chew on this next part. This is where it gets really interesting to me. There's this whole different legal question here. So the station had associates that, under its bylaws, had a say in its governance. The station fired all but one of them on January 31st. That prevented 100 of them from participating in the decision-making. Even before this bankruptcy, they had sued, saying that they could not have been dismissed in this way. That case is pending in circuit court. Should the bankruptcy judge be paying attention to that? How do these two things interrelate with each other?
Well, I mean, I'm not exactly sure what a federal bankruptcy judge has to do in connection with a state court related
these are
dispute.
Two totally different disputes.
But I do think that the management of the station that resulted in all these what were they? Partners or
DJs, associates.
DJs, associates, being fired and dismissed. I mean, I think that is part of what has led to this whole bankruptcy problem. And the other thing to think about in connection with this particular dispute, getting back to what Sarah was talking about mission, is that this radio station has a very different mission than any other radio stations around here. It's a community radio station. I mean, that's a very particular type of station. There's one that's very successful in Columbia. I think it's KOPN.
Well, the one here used to be very
and the one
successful.
here used to be, right. So I do hope that the federal bankruptcy court takes into account the special nature of community radio and also some of the background of how these various associates and backers of the station were pushed to one side.
And again, for those of you listening, if you do have questions, we're at 314-382-8255. That's 382-TALK. Judge Baker, it's all very complicated. The state court ruling could potentially affect the circumstances that got us into bankruptcy. So is there guidance for judges on how they're meant to deal with something that is happening simultaneously, but maybe not very quickly in a different arena?
That does happen on occasion. Even within the federal system, sometimes I would have a case that the parties were also in bankruptcy. So there would be a particular type of case, and then there would be a bankruptcy case. Many times in that situation, depending on the circumstance, my court will stay our proceedings, waiting to see what will happen with the bankruptcy proceeding. In this case, the state court proceeding was first. Mm-hmm. And so I will say that I'm going to make an assumption that the bankruptcy court is, of course, aware of the state court case. But whether it has an impact on their decision and how the bankruptcy case is resolved, I am not sure. And that would many times be up to the parties to actually ask that one or the other case be stayed, or that somehow the parties work together in the two cases.
It's interesting. I think you're going to see the parties in great dispute over whether this matter in circuit court should be allowed to proceed first. Sarah, this is just a mess. I mean, this whole matter involving KDHX has been a mess for some time. I know the parties that brought this bankruptcy, they would like to see this move quickly. One of these deals even has a bonus if they can get it moving quickly. Is there any chance of that happening, that this could all be done in a month?
I don't know. I have it. I don't know. Thank you, Sarah, for that question. I cannot answer in any way possible. It depends between the parties. Depends on the trustee. I mean, the trustee has an obligation to make sure the debts are paid. If the debt's $2 million and they're being offered $4 million, it's more than the trustee needs. He's going to start considering, alternate bids coming in, but unfortunately these alternate bids have not surfaced, so I don't know how quickly they can get it done. But I know that, but anytime somebody wants to rush, it's a red flag for me.
And that's what the two bidders, the two religious bidders, want to do. One of them said, "Well, I don't know how much longer we're going to have this 4.9 million."
This is a depreciating asset.
A depreciating asset. Yes, right.
So that's a red flag for Sarah. Is that a red flag for you?
Yes, it is. I mean, I don't think that. I do hope the court is not rushed by that kind of, gamesmanship.
So speaking of federal court, I want to talk about a case that is near and dear to my heart. Regular listeners to this show know that I am positively obsessed with Tanya Haddix and the tawdry world of chimp crazy. I'm always looking for an excuse to bring this back on to this very sober-minded roundtable. And once again, the gods have provided. Tanya Haddix, the star of this HBO docuseries Chimp Crazy, she's going to soon be sentenced on perjury charges for lying to a federal judge. She pled guilty, but comments she made on her podcast suggest she doesn't feel too bad about the whole situation. She's made comments on 8 different episodes, and some of them are about Judge Catherine Perry, the alleged victim in this case, a very respected jurist in federal court here. Judge Baker, can these be used against her?
Yes, and I believe that so she's pleading guilty before, I think it was a Judge Clark. I believe it's Judge Clark. She's pled guilty before Judge Clark and is awaiting sentencing. And he made mention of many of these episodes. So obviously he is aware of it. Okay, just a little inside information is that I didn't know any. This is not the type of television that I watch. And I knew...
I can't understand why, but pray continue.
And I didn't know anything about this, but in talking with my colleagues at the Eastern District, or my former colleagues at the Eastern District, they all started telling me about this Chimp Crazy and about the fact that Judge Perry was involved. And I even heard from Judge Perry, who was concerned about the fact that one of her proceedings, which was a Zoom proceeding, had been actually broadcast on the Chimp Crazy episodes. So I watched Chimp Crazy, which I'm not sure I will ever recover from. It's so bizarre.
Thank you for doing your homework.
Well, I actually had watched it before knowing about this, and therefore now I get to talk about Chimp Crazy, which I never thought in a million years I would get to.
Yeah.
So obviously everyone in the court is aware of this. Judge Clark is aware of this. I'm sure the prosecutors made sure that he was aware of any statements that were made by her during her podcast. So to your question of whether or not this could be used against her, absolutely it can be. Because she's obviously not showing any remorse.
And that's something judges want to see.
Right.
Yeah.
When you plead guilty, that is part of the process, and it's going to play into her sentencing.
So, Sarah, the look on your face when Judge Baker explained, I see you are not a super fan of Chimp Crazy. You did not realize that she had, allowed camera crews to watch this Zoom proceeding and then broadcast it to HBO viewers, when judges apparently don't like when you do that. This was a shock and horror to you.
Yeah, I've not watched. I mean, I know the case, and I know that she was hiding the monkey. She claimed it was dead. She lied the...
It's an ape, Sarah.
Yes,
chimp. I'm sorry, chimp. She had this chimp. PETA sued her. She claimed the chimp was dead. She presented ashes. It wasn't dead. She lied to Judge Perry. Like, I have followed it.
Thank you.
Loosely, but it's also not my source of news. So yes, I was horrified when Judge Baker said that poor Judge Perry's judicial proceedings were aired on HBO.
And why is that such a big deal? I would just think, okay, the courts are open to, journalists are allowed in there. It's open to the public.
The courts are open to journalists, but we do not allow recordings in our courtrooms. And when, after COVID happened and we started doing these remote proceedings, I don't know how many times we tell the parties, we tell everyone on the proceeding, this cannot be recorded. I know that Judge Perry did that in this case. It can't be recorded, let alone rebroadcast. And that's exactly what she did. And that, I will tell you, did not make Judge Perry happy.
Yeah.
Yeah, I think it just ties into this notion of no remorse, deceit. You lied about the chimp. You're lying about recording it, you're playing it for HBO for publicity. It just all starts to entangle with. It's not simply no remorse. It's just flagrant disregard, disrespect. And I'm actually not offended. I don't want to say this to Judge Perry, so please don't report back.
Don't tell her, huh?
Miss Haddock said that the Judge Perry was not fit to make sound decisions. I don't love the statement. I wouldn't make the statement, but I don't think that statement in and of itself would garner additional severe punishment. I don't think that's the problem. I don't agree with it, but I don't think that's the problem. I think the problem is the lying about the chimp being deceased and then lying about the recording being made. That bothers me more than because I think we should be allowed to have opinions on our judges.
I agree with that.
Factual based opinions, not reckless untruths. I just don't agree with that comment.
So, HBO obviously not a party to this lawsuit, but they did have cameramen that then broadcast that. Could there be any ramifications for them that they broadcast this court pleading that Tanya Haddock was not supposed to allow them access to?
That is actually a very good question, and I think that is a question that the court has considered. I don't know how it is. I know that is. They understand that it was HBO. It was not Tanya Haddock. I mean, even though she allowed them in there, she wasn't the one who actually put the final product on the air. So I think that could they be responsible? Yes, they could be. But whether or not they will be held responsible is a different story.
That doesn't matter to me whether she created the final product. When I hire a hitman, I'm still responsible. Right, I didn't pull the trigger, but I'm responsible for putting it into action. So she is responsible for whatever they produce. That doesn't.
I appreciate you stipulating to that. If you ever hire a hitman, I'm going to play those words back in court, and there goes your defense. But Judge Baker,
but the thing is, you didn't watch it. So one of the things that I got out of watching it, and I will tell you, those are hours I will never get back in my life. But having watched it, you realize that the HBO people are using Tanya Haddock.
Yeah. She does not come off well in this series.
Right. But they put her in this. They knew this was going on, and they used her. And they used her for their benefit to have this product at the end. She's not the one who said, I want HBO to come in here and do this. They actually got to her and asked her to do it.
So we need to take a quick break here. We're talking to our legal roundtable about some very important legal matters. Chimp crazy. That was retired Judge Nannette Baker. We're also joined by Sarah Swatosh and Bill Freivogel. Coming up next, staff shortages plague the Missouri Attorney General. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back to our Legal Roundtable. I'm Sarah Fensky, in today for Elaine Cha, and joined by an expert panel of attorneys. That includes retired Judge Nannette Baker. She's the former Chief Magistrate Judge in the Eastern District of Missouri, the former Chief Judge of the Missouri Court of Appeals in the Eastern District of Missouri, and a former Circuit Court Judge for the City of St. Louis. Also joined by Sarah Swatosh, a labor and employment attorney now in private practice at the Law Office of Sarah Swatosh, and Bill Freivogel, an attorney and professor for the School of Journalism at Southern Illinois University, Carbondale. So the Attorney General's office is struggling to keep attorneys, and that's causing problems for the office and also the people who are trying to fight it in court. In 2024, nearly a third of positions were vacant, and lawyers say that's affecting their lawsuits against the state. Tony Messenger of the Post-Dispatch had a really good column about this, just exposing a situation that apparently had been thrumming along problematically for a long time. He quotes attorney Nimrod Chappell. Mr. Chappell says attorney after attorney made an entrance in a case he's handling, only to later leave. Chappell finally filed a motion for default judgment. He said 1,751 days had passed since the petition had been filed. The defendants still had no answer on file. That motion was not granted. Bill Freivogel, are you surprised by that? That seems absurd to drag this out this far.
Well, it's terrible. That's not justice. I thought Tony had it, as Tony put it in his column, Tony Messenger, Bailey's lawsuits against the federal government, China, Starbucks, local school districts over culture issues earn him face time on Fox News, but it seems at least part of his job of running the office might need more of his attention. Those cases that have these long, 1,000-day, 1,500-day delays, I mean, that's ridiculous.
It's very concerning, and I hate to put this on the judges because this is not a situation they created. This is a situation created by a short-staffed attorney general's office. But is there anything that they can do to sort of hold his feet to the fire and make sure that he remedies this situation? Judge Baker.
They can grant the default judgments in those cases. That will get if a judge or two started doing that, then the Attorney General's office would pay attention. And even after a default judgment is granted, they can still appeal. They can still, ask that it be undone. But that's the only way in a situation like this that I think you can get the attention of the Attorney General's office.
Do you think they're loath to do that because this is a state actor? If this was just some random lawyer who couldn't get his act together, he might well suffer a default judgment. Sarah?
The city of St. Louis is granting defaults against Sheena Hamilton's counselor's office. They are granting them. And then the counselor's office says, oh, geez, yep, sorry, missed that one. And they are going back to the judge saying, sorry about that. Can you set it aside? And the city judges are setting it aside.
Interesting.
So I think the city judges are getting the city counselor's office attention. I would like to see the state judges do it with the state of Missouri as well.
Do you think there'd have to be some sort of orchestrated effort where judges would confab with each other and say, okay, this situation is untenable, or just each one sort of acting in their own way can make things move forward?
I think that is maybe the problem, is because these are not all before the same judge. It's in different places, I think. And so I think that could have an effect. Just because, for example, given the city of St. Louis situation, all the judges are in one place. They are dealing with the same actor, and now they're saying, okay, we've just got to get these things moving. So, but I think a judge could just start granting those.
Sarah?
And I'm a plaintiff's lawyer. Shame on the plaintiff's lawyers. If I'm not getting an answer, I'm not waiting 3 years to file a motion for default. What are you doing in the meantime? And if I'm not getting an answer, at the 3 or 4 month mark, serve requests for admissions. Requests for admissions, the party who receives them either has to admit the statement or deny the statement. And if they don't admit or don't respond, they're all deemed admitted. So if I serve requests for admission that says, admit that your client sexually harassed my client, and they don't respond, it's deemed admitted as a fact. So, hey, plaintiff's lawyers, don't rely on the judge to do your work. Do some of your own work.
It's interesting. Lawyers could be a lot more aggressive in some of these cases.
We could be.
I'd like to see the voters paying a little bit more attention to this attorney. I mean, he won. He has bragged about having the biggest win of any of the statewide, even more than Trump in Missouri. But I mean, he while he's delaying these other cases, he's having time to intervene in the hush money case in New York on behalf of Trump. He's calling for the Trump administration to investigate whether Biden was mentally unfit and couldn't grant pardons. He was just in court last week trying to get the names of minor women seeking abortions in Missouri.
So this is just a matter of priorities, you're saying?
Yes.
Okay. Well, it will be interesting to see if maybe plaintiffs' lawyers will take the call to action that Sarah has issued. Maybe judges will take the call to action that Judge Baker notes that they can do here. It sounds like there's ways people can deal with this system. ProPublica, they had a blockbuster report this month on Ed Martin. He's the longtime St. Louis lawyer. Just about everybody in town has at least 3 stories about this guy. He's now Donald Trump's nominee to be U.S. Attorney for the District of Columbia. Now, this ProPublica story shows how he was revealed in court filings filings to have ghost-written attacks on a state court judge in the Metro East. Legal experts told ProPublica that Ed Martin's conduct in the Eagle Forum case was a clear violation of ethical norms and professional rules. So, Bill, I'm reading about this, and I see that Ed has sort of encouraged somebody, to sort of make these nasty comments about this judge and helped write them. But this woman gladly put her name on them. She kind of was happy to have a ghostwriter. Why is it such a big deal that Ed Martin did this? Where did he cross the line in terms of legal ethics?
Well, where he crossed the line on legal ethics is that, he was a party to a lawsuit, and was going against him. The judge had ruled against him, and you're not supposed to be trying to take out of court steps to influence the judge and social media and the like. This was a case. So this goes back to around the time Phyllis Schlafly died, and Ed Martin was her right-hand person, and she left him in charge of it. Phyllis Schlafly's daughter and the board contested it, kicked him out, went to court to say, keep Ed Martin away from Eagle Forum, and the judge ruled in her favor, the daughters.
And Schlafly Corey.
Right. And so some of the things that Ed Martin was, Ed Martin wasn't so, not only so happy to ghostwrite, but he also bought her a computer that she could use in the process.
Of filing these nasty complaints about the judge.
Yes, right. So amongst the things he suggested she write is, this is not justice, but a rigged system. Shame on you in this broken legal system. Call what he did unfair and rigged over and over again. He's doing like Hillary does. And then he suggested that she make her posts organic and send a personal message to the judge.
So he was really guiding her hand here.
He was really guiding her hand.
As he's a party to this litigation. Sarah, thoughts on this?
I'll go back to my hitman analogy.
Oh, I'm glad you're returning to that.
Right. Ed Martin has hired Priscilla Gray. He's given her a computer, and he tells her, say rigged over and over and over. He's telling her what to say. He's telling her to have contact with the judge. Lawyers, parties aren't supposed to contact the judge about their case outside of the courtroom or outside of proceedings, and you can't use a third party to get around that rule. And so I read it and I thought to myself, this is just deceit masquerading as advocacy or professionalism, and it's outrageous. It is. If I assume there's a bar complaint pending somewhere. I haven't seen it.
Well, Anne Schlafly Corey tried. She tried to get him held in criminal contempt of court. They said, go talk to a prosecutor. She filed a bar complaint. Nobody seems to have taken this seriously until suddenly he's the nominee to be U.S. attorney.
I did some research. Lawyers have been disbarred for this type of conduct, for harassing the judges. And we are allowed to complain about judges as long as there's some factual basis. It just can't be sheer harassment, and it can't be just sheer lies.
And this crossed the line from what you saw.
This absolutely crossed the line. I don't know how he hasn't received some sort of ethics complaint, censure, disbarment. It's really shocking. But I think it happened in Illinois.
It did.
It did.
And so maybe Illinois said that's Missouri's taint. We're not getting into it.
Well, he's had a lot of ethics complaints filed against him.
Yes, he has.
There's the D.C. bar.
He continues
example.
to practice law.
He manages to get by. I mean, only last week he was. It turned out he hadn't mentioned to the Judiciary Committee that he had 100 interviews on Russia Today and Sputnik. Here's the guy who is supposed to be in charge of investigations of Russian spies, who is on these broadcasts spouting Vladimir Putin's talking points.
So this is a St. Louis original now being exposed to a much wider audience. It's going to be interesting to see if they tolerate him as well as St. Louis has. Sarah, we have less than a minute here, but I got a quick question for you. So the 23andMe company is folding up its operations. It has about $277 million in assets to be sold, $214 million in debt. It's in bankruptcy court. It's filing in St. Louis. Why St. Louis?
St. Louis has an exceptional bankruptcy court. They have handled several large, complicated bankruptcy cases. I just think this is this is one of the best venues to go to. They know what they're doing. They've handled Foresight Energy, Briggs & Stratton Corporation bankruptcy. They know what they're doing.
So we're now a destination for someone with a really complex bankruptcy if they want it handled right.
Yeah, I don't think it was a strategy to get an upper hand or to cheat somebody. I think these judges know what they're doing.
Well, Sarah Swatosh of the Law Office of Sarah Swatosh, thank you for joining us today.
Thank you.
And former appellate judge Nannette Baker, thank you so much for joining us, sharing all your expertise. It's just been great having you make your debut today.
All right, thank you for having me.
And Bill Freivogel, professor for the School of Journalism at Southern Illinois University, Carbondale, thank you.
Thanks.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.